an appeal in the matter of Merck & Co and others and Merck KGaA.
Yes, Mr. Thompson.
My Lords, my Lady, I appear on behalf of the appellants with my learned friend Mr Hollingworth, Mr Speck and Mr Brandrick appear for the respondents. Your Lordships, the Court will have seen from the appellant's notice that we are appealing with permission from the judge at first instance. There are 4 branches to the appeal. I'm proposing to address your Lordships, address the Court in the order in which they are addressed in my skeleton. We've had a division of labour, so Mr Hollingworth will address you with your Lordships, with the Court's permission on factual aspects of the grounds of appeal, rather than bob up and down at different intervals as we go through. The factual aspects arise primarily on the second branch, which is the effect of Amazon in the Supreme Court targeting and use in the course of trade in the United Kingdom. So if I can start then with the question of declaratory relief. The judge at first instance, when giving permission on this, said at the order for form of order hearing that actually after he'd delivered his judgment, he queried why there didn't seem to be a body of authority implementing the declaratory relief procedure in relation to contempt or quasi-contempt or breaches. And he said that he'd been steered towards a case which is fairly notorious in the IP sector, which is a case called Whit-Marley, in which everything got into a bit of a procedural tangle. This was a case in the 50s. And he said that that was influential, he said on the transcript, in giving permission to appeal on what he regarded as a compelling reason for settlement of the practice that we are dealing with in relation to declaratory relief vis-a-vis breaches of court orders. Now, could I ask you, I believe the court is working on hard copies, which is certainly beneficial from my point of view. Could I ask you to turn to our skeleton, which is behind tab 2. And I was proposing, note the past tense, I was proposing to start with paragraph 38, which is on bundle page 31, rising to the top of page 32. And if I could just ask the court to refresh its memory by reading paragraph 38. Now, I had intended to cite, and I'm certainly not disavowing any reliance on the Supreme Court decision in the Christian Institute, it's in the bundles. But what happened is that as we went to press on our bundle of authorities, the judgment of the Court of Appeal in Tesla landed. I can't remember the exact day. The court will remember better than I do, but I think it was about 10 days ago. And so what I would like to do is to make that point, which I would otherwise have extracted from the Christian Institute and the Lord Advocate, to make it by reference to the Tesla case, which has been added to the authorities bundle at the very back end. And the ECHR principle requires that there should be a legal standard. And if I've read and correctly understood the Tesla case correctly, the Court of Appeal in that judgment was keen to stress, or indeed not just keen, did stress the need for a legal standard when you're proposing to grant declaratory relief or refuse declaratory relief. Now, could I therefore ask you please, with that introduction, to turn to the authorities bundle, tab 20, where the Tesla case is to be found. Sorry, tab 13 in the authorities bundle. The judgment is comprehensive in relation to the evolution of the principles relating to declaratory relief, and if you'll forgive me, I would like to just trace it through a little bit.
You want to explain for my lady's benefit that it's a minority judgment.
Yes, it is a minority judgment.
And the majority neither expressly concur nor expressly dissent from what is said about declaratory relief.
I understand. If I have to, I'll adopt, as an advocate, I will adopt the narrative history of declaratory relief. As you know from this judgment, there's been a history of minority judgments in relation to declaratory relief in the Court of Appeal. And speaking as a consumer of judgments in the Court of Appeal on declaratory relief, it's been a bit unsettling to know where the parameters are. But may I, if I need to, I will adopt this narrative. If I may say so with respect, it chimes with everything that I'd previously known about this subject, and I do feel it's important to trace it through. As I understand it, the difference of opinion on the court was between whether there was or wasn't a legal standard relative to which declaratory relief could be granted. Okay, so may I take you to, if it's paginated, it's 230, and it's paragraph 47, the law as declaratory relief. My Lord Justice Arnold reviews the history of it, starting with the early enactments on this subject. They're there to be seen. What I would draw attention to is that even running forward from 1850, which you see in paragraph 48, where you see the Court of Chancery Act, and then you see that quite quickly picked up again in the Chancery Procedure Act 1852, the expression that was always used was a declaration of right. And the history of it shows, the legal historians will tell you that the history of it shows that the judges were extremely reluctant to pick up with the latitude that was on the face of it being given to them by the statutes, and in their reasoning, in their judgments, and there were quite a few of them, they focused on the question of the word right and declaration of right and the connotations that they saw attributable to that. So you have a situation in which the statute tells you from the very beginning you can have binding declarations even though no other relief is claimed, but it's anchored in the concept of declarations of right. If I turn the page again, you get to paragraph 50, and you'll see the same language is being used in the statutory provision. Well, it's actually the Rules of Court there, Supreme Court, 1883, binding declarations of right, and this continues. And as it happens to be the case, the expression declaration of right appeared in the RSC for many years until it was eventually dropped in what is now CPR 40.20. Now, the Guarantee Trust case against Hannay, from memory that was one of two cases. The other one was Dyson versus the Attorney General at around about a similar point in time, in which the Court of Appeal at that time, shall I say, liberated the declaratory relief procedure. So you reach the point where, as my Lord Justice Arnold says here in 51, that Hannay's case stands for the proposition you can have declaratory relief even though there's no cause of action against the defendant. Now, if we pause for a second, look at the liberation that we're having here. You don't have to have any other claim, you don't have to have a cause of action. Then you get down to 40.20, and you'll see that 40.20 drops the language of declaration of right. I can't remember when it dropped out of the RSC. I think it was RSC Order 15, Rule 16. I can't remember, but it dropped out at some point during my lifetime anyway. And you'll see that it is as liberated as it can be from its statutory origins by the time you get to CPR 40.20. As my Lord has pointed out, and as I think is common ground, or should be common ground, the rule is not the source of the jurisdiction or the power. If I use the word jurisdiction to mean power, the rule is not the source of the power. It just tells you that the power can be exercised whether or not any other, and note the word remedy, whether any other remedy is claimed. Now, then it's traced through various case law, but the cases which are always cited, unless they're overlooked anyway, they're always cited in any serious examination of the subject. You have Messier Doughty, and you have Mr Justice Neuberger in Financial Services and Rook. Those cases, they are absolutely staple diet in any declaratory relief case. Now, when you get to Messier Doughty, the famous passage is quoted there in 55, and this is where Lord Wolfe stresses, it's halfway down the quote at the top of page 232, stresses the question is whether it would serve a useful purpose. He says the approach is pragmatic. The deployment of negative declaration should be scrutinised, their use rejected where it would serve no useful purpose. However, where a negative declaration would help to ensure that the aims of justice are achieved, the courts should not be reluctant to grant such declarations. They can and do assist in achieving justice. And then it's the last sentence or so of that paragraph. Should not be constrained by artificial limits wrongly related to jurisdiction. It should instead be kept within proper bounds by the exercise of the court's discretion. Now, if I just draw breath, we've got, you don't have to have a cause of action, you don't have to have any other claim. You can mount a claim for declaratory relief, and certainly by the time we get to this judgment that I'm quoting from here, it's pragmatic, it's a matter of discretion, and it's not limited by what the judge, the Master of the Rolls, called artificial limits on jurisdiction. It's as pure a discretion as you can get if you follow all of this through. And then the next case, which came not long afterwards, I think, which is Mr Justice Neuberger in Financial Services and Rook. That was an extempore judgment, I should say. There are some statements in there that you could disagree with about what the nature of the declaration was that the judge granted in that case. But you'll see that in the second line of the quotation inset into paragraph 56, the power to make declarations appears to be unfettered. And then the judge goes on to talk about the exercise of the unfettered power, and he gives, in his famous concatenation in paragraph 57, the principles one way and the other. Now, in my respectful submission, those would be the hallmarks of any just remedy. Every remedy that was a just remedy would meet those criteria in those general terms. Those criteria do not, in fact, unshackle the jurisprudence from the extremely broad discretionary complexion that it wears, or did wear, I say, until recently. Now, in paragraph 59 is Mr Justice Pumphrey's summary, 59, Mr Justice Pumphrey's summary in a later case of Interdigital, and he's got 3 numbered points. So number 1, top of page 233, it's one of discretion rather than jurisdiction. There's a slight, you're familiar with the way in which the word jurisdiction is a slightly ambiguous word. In this context, I'm sure it means power. So it's one of discretion rather than jurisdiction in the sense of constraints on power. Is the useful purpose test and the aims of justice. All of this is, I think, taken from Messier Doughty. And then 3, the underlying issue must be sufficiently clearly defined to render it properly justiciable. Sufficiently defined. You would expect that as a basic starting point of any claim for declaratory relief, that it be properly defined. Now, in paragraph 64, you have counsel for, if I pronounce it correctly, Avanci, submitted that it was not sufficient for the grant of a declaration that it would serve a useful purpose. The purpose must also be a legitimate one. My Lord says, I don't understand that to be an issue, but in any event I accept it, and it's supported by Teva. May I pause there? It's important for my case that there should be a legitimate purpose, something you can identify as legitimate. Normally you need some criteria for the purpose of deciding what's legitimate and what's not legitimate. And may I say, with no disrespect, it's a truism. Because if you consider the antithesis, you couldn't possibly conceive of a court in the exercise of its discretion granting a declaration or any form of relief for something it regarded as an illegitimate purpose. So it's a truism in my respectful submission, but it's one which is really important to keep in mind, because in my submission, what we're seeing here is a sharper focusing as we go down through time of what starts out as an extraordinarily broad, unfettered jurisdiction to grant declaratory relief. Now, I note in passing, we have in paragraph 70 is the reference to the minority judgment of Lord Justice Aikins in the case, again, which is always cited where there's a serious discussion of declaratory relief. That's Rolls-Royce and Unite the Union. But again, it's a dissenting judgment. Well, it's not a dissenting judgment. It's a judgment that didn't carry the other two members of the court with it. Now, it's always cited, and what Lord Justice Aikins did, what he wanted to do and what he did, was to establish some tests. And of course, it's necessary to have tests if you're not going to have an unbridled jurisdiction. You've got to have some litmus tests up against which you can analyse the case in front of you. And so his sweep up was in subparagraph 7 at the top of page 236. In all cases, assuming that the other tests are satisfied, the court must ask, is this the most effective way of resolving the issues raised? In answering that question, it must consider the other options of resolving this issue. Then Milebush is introduced at the bottom of page 236 in paragraph 72, and my Lord reviews the authorities and the way the judgment came to be delivered. But you'll notice again in paragraph 76, Lord Justice Moorbrick dissented. So by now, looking at it purely through the lens of a practitioner, we've got two modern Court of Appeal decisions in which each of them, the meat of it for everyday practice on declarations is in minority judgments. Now my Lord reviews Lord Justice Moorbrick's judgment, and he later goes on to say that he thinks and says that there's a lot to support. It's right, basically, there's a lot to support.
Well arguable, I think, is what is said.
I beg your pardon?
Well arguable.
Well arguable.
That
yes.
is correct.
Yes. If I had to argue it as well arguable, I would say that's what it says. Vestel was new to me until I read this judgment. So Vestel is introducing the observations that were made in particular by Lord Justice Burse in that case. And I'm going to, if I may, take you to the paragraphs in which Lord Justice Burse made the observations which I see as pertinent to my case. So 239, paragraph 81. My Lord Justice Arnold is introducing what Lord Justice Burse goes on to say, shows that it's rooted in those famous cases of Messier Doughty, FSA and Rolls-Royce v. Unite, and Milebush. So there they are. That quartet of cases is always there. And you'll see paragraph 77 in the indentation, towards the end of it, therefore Pfizer, which is the high point of Vestel's argument on this topic, is not an example of the court holding that the declaratory relief jurisdiction can be engaged on the sole basis that it would serve a useful purpose and in the absence of any putative legal claim at all, or any, and then here are the words which get reiterated, or any legal standard against which to judge the matter. The need of a legal standard against which to judge the claim declarations is important. That's paragraph 78. Paragraph 79. It's hard to know how to decide whether the declaration sought, untethered to any legal standard, actually could serve a useful purpose. Now, my Lord Justice Arnold then sums up in 83, where he's adding 4 points to the 3 that he'd already identified in paragraph 59. The purpose served by making the declarations must be not only useful but also legitimate. In order for a legal issue to be properly justiciable, it's necessary for there to be an applicable legal rule or standard. In exercising the discretion, the court must consider the effect of the declaration not only on the parties, that's not applicable here, then the court should also consider the availability of alternate remedies. Now, just for completeness, for my lady's purposes, my Lord Justice Arnold disposed of the appeal. It's on page 273, rising to the top of 274. My Lord Justice Phillips, his judgment begins, as you can see on page 274. And I draw attention, if I may, to paragraph 235, which is on page 276. In which my Lord Justice Phillips disagrees on whether there was or was not an applicable legal standard invoked in relation to the claim declaration, and he explains why. And then at the top of the next page, in paragraph 236, Tesla has not pleaded a recognised legal standard against which friend could be determined. And then Lady Justice Whipple, on page 279, agrees with Lord Justice Phillips, and that is how we end up with a minority judgment. Now, as I said, I am reading the observations of my Lord Justice Phillips, and no doubt if I'm wrong I will be corrected, as recognising and accepting that in principle it's right to have a legal standard against which to test whether there is declaratory relief. It's right. I'm not detecting a dissent on that basic point. I'm detecting that the dissent is located on the question of whether there was or there wasn't such a legal standard in play in that case. Now, the reason I took you to my skeleton...
What is in relation to declaring friend, you have the Supreme Court in Unwired Planet.
You do.
So that's where the requirement of the legal standard in declaring friend comes from.
I would say that Frand is not a special case when it comes to the question of declaratory relief. The need for a legal standard, that's why I opened up on paragraph 38 of my skeleton. I was going to make these arguments anyway on the basis of the Supreme Court and the ECHR principle of legal certainty. There's no doubt that the ECHR requires, and the Supreme Court judgment bears it out, you must have a legal standard, otherwise you've got no protection against arbitrariness. Everybody could be dragged to court and the justice would be like, proverbially like the Lord Chancellor's foot, which is, if it ever was correct, it can't, in the era that we now live in, it can't be the law now.
Yes, I'm not suggesting that your general proposition is wrong, but one has to understand that in this context, you have the Supreme Court in Unwired Planet, and then you saw in Vestel, that was the basis of Lord Justice Burst's analysis of the legal standard.
Yes.
And that is, at least that's what I understood, was the basis of the dissent. Sorry, the disagreement, and why Lord Justice Arnold's judgment was not agreed upon by myself and Lady Justice Whipple.
Yes, but it doesn't trouble me, if I can put it that way with no impertinence, because Lord Justice Burst himself was rooted in what I called that quartet of cases. And as I've said, the great problem for practitioners is that there's the minority judgment, there's the wide words on discretion. It's really only when you get to Vestel, which I wasn't familiar with on the question of the legal standard, and when I see it here as being front and centre of the analysis in this judgment, that I am encouraged to rely on this authority as locating my argument where I wish to locate it. So I don't have any problem with the fact that Frand is a regime which is very troublesome to invoke, and it produces a patchwork of results all around the world. Put that on one side, I'm focusing only on the question of when it is or isn't appropriate to grant declaratory relief.
Yes. But it supports your case.
It does.
That the Supreme Court viewed that there was no jurisdiction, using that term as they used it, to determine, i.e. declare, Fran rates or Fran terms in relation to packages of SEPs that included foreign patents,
Yes.
unless there was a contractual
Yes.
obligation.
Yes. I haven't done as many Frank cases as the members of the court have, or indeed as my opponents have, but I've done some. And you've got ultimately this tension between the territoriality of patent protection and the worldwide footprint of the licensing, which is usually deemed to be FRAND, or at least regional licensing deemed to be FRAND. So I'm dropping anchor then on the point which was in 38 of my skeleton, if I've remembered the paragraph correctly, the need for a legal standard. I'm finding reinforcement for that not only in the Supreme Court decision I cited, in the basic principles of ECHR protection, I'm finding it also in this recent judgment in the Tesla case, and then I switch the question to the next question. What is the legal standard? And in my argument, the legal standard, if you're going to invoke declaratory relief for the purposes of asserting that there's been breach of a court order, is actually the legal standard which is embedded and built into CPR 81. CPR 81 is itself the modern incarnation of a jurisdiction that the judges have always had and always asserted to, what should I say, attach consequences for breach of court orders. The books are as old as the hills on this. Oswald on Contempt is a fascinating read from the late 1880s. Now, in the modern world, it has been necessary to make sure that the contempt jurisdiction is properly parameterized within the scope of what is now CPR 81. And CPR 81, as you know, has itself been fleshed out by quite a lot of case law in order to make it ECHR compliant. So the second base in my argument is you need a legal standard for declaratory relief, and in the context of a claim for declaratory relief that there's been a breach of an injunction, then the parameter for that, the legal framework, the legal formula, is that which is actually embedded in CPR 81. Now, I will immediately recognise that there are plenty of cases, and in the commercial court, so far as I can tell, watching from the outside as the judgments come and go, there is, it's quite a regular occurrence for somebody to come along and seek a declaration about the scope of a worldwide freezing order and some of the provisions on it. It's quite common, and it seems to me to be quite common anyway, and that is indeed what what happened in the case, the Ablyazov case, which is in the bundle that went to the Supreme Court. And I won't go to it because I don't need to, but I will just to furnish my argument with an example on this as to what the declaration was that was sought in the Supreme Court. It was refused at first instance in the commercial court, it was refused on appeal to the Court of Appeal, and it was granted by the Supreme Court, and it was this: if the loan agreements constituted valid contracts, defendants' rights under them could only be exercised in accordance with paragraph 9 of the freezing order, which set out a regime. So my argument does not go so far as to say you can't have declaratory relief which touches and concerns the operational implementation of an order. My argument goes to the point that if you're going to go what I'm going to call vernacularly the whole hog of claiming declaratory relief that there's been a breach of the injunction, then in those circumstances you put yourself by that claim in the realms of CPR 81, and the rule on declaratory relief doesn't enable you, in my respectful submission, to bypass that basic principle. Now, of course, there's no absolute never is never is never in relation to a discretionary power. It's always possible, and the court always guards itself against overstating. I'm going to come to a position in which I'm going to submit, forgive me, in which the policy of the law is clear, that you don't have a halfway house, that you don't mingle civil and quasi-criminal procedures, and that a declaration that something has or has not incurred criminal liability or quasi-criminal liability must be regarded as truly exceptional. So that's an indication of where I'm going next. Now, before I get to that, in terms of case law and so on, may I show you exactly what the contours were of the declaratory relief in the present case that was sought, or the application for it. In the C bundle, the core bundle, if I can take you please to tab 10 first of all. So this is, I'll call it the originating application. It's the statement of case in support of the application. The application form itself is later on in the bundle. That is behind tab 17, but I don't think I need to look at it. So here you have the application for declaratory relief. This is the 3rd of March 2022. You see, if I can pick it up at the meat of it, there's a reference in paragraph 9 and paragraph 10, the provisions of what we've called the final order, which is the final order of Sir Alistair Norris, which is 28th of July 2020, and there's a recital of paragraphs 2 and 3, which are the injunctive provisions. May I turn you please to paragraph 14 on page 221 in the bundle? So Annex 2 is a huge schedule of breaches of the order. If I drop you down to subparagraph F, the presence of the signed Merck was in each case the result of a deliberate decision by employees of MSD defendants to place the material, including the use of the signed Merck on that website, in that communication. In no case was it the result of technical error. Paragraph G. Paragraph G is, I think, resonating with the exception to the order in paragraph 4, little h. Further, in the premises of these matters and of these uses having arisen and not having been addressed until raised by the claimant in correspondence, the MSD defendants have no adequate processes in place for ensuring compliance with the terms of the order or monitoring compliance with the order. Now, if I can then go to tab 13 on page 288, please.
Are you going to take us to paragraph 19? After all, that's where the declarations are.
Yes. Amount to a breach in each case.
Yes. Now, if you were to add the word would in front of amount to, would you be making the argument you're making?
Yes.
Why?
Because the assertion of a breach is an allegation of conduct which is going to be a violation of a court order. It involves...
So even if you're asking in the abstract, would this amount to a breach, that would still mean that you've got to go through the whole panoply of CPR 81. That's what you're seriously suggesting.
Yes, I am. And I'm going to show my lady the authorities which I say point in that direction. So can I take you to page 288 in the bundle? I'll draw your attention, if I may, to paragraph 3b. It's admitted and averred that the breaches of court orders may amount to contempt of court, which is responding to a pleading we'd put in. It's further admitted that an application for contempt of court has strict procedural requirements because it raises issues of the liberty of individuals. This is not an application for contempt of court. For the avoidance of doubt, though, the claimant contends the same is already clear from the terms of its application. The claimant will not bring contempt proceedings in respect of the specific acts identified in the claimant's application. It reserves the right to bring contempt proceedings in relation to 1, new acts, or 2, acts identified as breaches in these proceedings that continue or recommence after the date of any declaration in relation to them. To that end, there is real utility in disputes over the interpretation of the order being resolved in advance of any such application. Now, this is actually corresponding to what in other cases has been called creating a halfway house, in which, on the civil standard, findings are being sought of breach, and they are intended to be used as a platform going forward, notwithstanding that the procedure in which the declarations will have been made, if they're made, are to the civil standard under CPR 4020. Then come to C, if I may. If I pass it down to about 3 or 4 lines in, it's averred that an application for a declaration in relation to the matters identified in the claimant's application provides an appropriate low-key method of resolving the disputes between the parties, including over the construction of the order, thereby enforcing the order and preventing future breaches. Again, it's the same point. It's an enforcement mechanism. If I can turn the page to page 289, little c, under paragraph 9. This is on the construction of paragraph 4H. The assessment of whether any deliberate action by an employer or agent of the defendants or any of them falls within the provisions of paragraph 4H of the order requires assessment of the context of each individual act, the pattern of such acts, their number, nature and persistence, the steps taken by the defendants to ensure compliance with the order of the court, and the technical measures available to and employed by the defendants to ensure that breaches of the order, being breaches of contract and or infringements of trademark, are prevented. In particular, it's denied that paragraph 4H is intended to permit the defendants deliberately to carry on performing acts that are in breach of the provisions of the order until notified to that effect by the claimant. Paragraph 10, in the premises of the defendant's denial that they have acted in breach of the order, there is a real dispute between the parties as to the scope and effect of the order and the defendant's compliance with its terms, further in the premises, and so on. This is not just about interpretation, it's actually going the whole length of asking for an adjudication of breach of the court order.
So if it were just a dispute about interpretation, let's suppose you've got 2 parties who genuinely dispute what a court order means.
Yes.
And one party says, I think I can do X, and
Yes.
the other party says, I don't think you can do X.
Yes.
Do you accept that you could go to court and get a declaration as to whether or not it would be possible for party to do X or not?
There are ways in which you can do it, and the form of, if I model it in this way, the question would be, is XYZ prohibited by ABC?
Well, what's the difference between that and would it be a breach of the order?
Because this order has got built into it many, many exceptions in the form of paragraph 4. You can only get to the question of whether it's a breach by going through the whole exercise of construing the judgment, the order as a whole, and then allocating the conduct to the question.
That, with respect, is not an answer to my question. The fact that it may be a long, difficult and tedious exercise does not mean that there is not a distinction without a difference. What I'm putting to you, Mr Hobbs, is what is the difference between what you've just said, which is a declaration as to what the order means and whether something would be prohibited by it,
Yes.
and asking whether something would be a breach of it? They seem to be 2 sides of the same coin to me. We're just playing with words.
I beg to differ, my lady. If you're seeking a declaration that someone has breached a court order, you are actually asking for the very conclusion in point of law that you would be asking for if you were making a committal application.
My question was not, have they postulated on the basis that somebody had breached a court order. I chose my words very carefully. I asked you what was the difference between saying that something was prohibited by a court order and that something would be a breach of it.
Because the prohibition in an order, if you're going to assert breach on the one hand, requires you to show everything necessary for breach. If you wish to construe the wording of the order in terms which do not come freighted with the accusation of breach, then in those circumstances it may be possible to articulate a form of wording which meets that point. And I don't know whether you've noticed, but in our grounds of appeal in box 9, we have actually proposed declarations that we say would meet the, because I'm not saying there should never be declarations about the meaning and effect, we've proposed declarations that would, we say, meet the questions which have divided the parties. I don't know whether this would be a convenient moment to turn it up. In the, just bear with me for 1 second. Yes, so in the core bundle behind tab 1, on page 18, at paragraph 2, we have indicated that we would invite the court to consider what I understand to be declarations along the line that my lady was putting to me. And that is drawn from the experience of having argued out with my opponents the whole question of all of those 50 some odd instances as to what the central points were of difference on construction of the order. So I'm not saying you can't have declarations, far from it, about the construction of an order. But that isn't this case that I'm bringing to this court on appeal.
So just to make sure I've got this submission down, you can have declarations as to the meaning of an order. You can have declarations as to what activity might be prohibited by an order, but you can't have a declaration as to what would be a breach of it.
I'm going to the point that what has been a breach of it, whether you can get a declaration that this is something it would or wouldn't be, I'm going to say is a delicate issue, because I've said my submissions are that the policy of the law is clear, that you don't have halfway houses on this. So, just pressing forward.
In the case of a continuing alleged contravention of an order, what's the difference between determination of what was done in the past, did or did not contravene, and a determination as to whether continuation of the same act would or would not contravene?
Because of the parameter that my Lord has just put to me, I would answer it in the way that I've been answering my lady's questions. Because the fact that there is a continuity there doesn't alter the fact that there is a declaration that there has been a breach of a court order.
So I think it comes down to the dividing line between the past and the future.
When you're looking at the future, there is still, as I'm hoping to show your lordships, there's still a need for care and consideration. No halfway house. And that's because, as I have spent some time opening to your lordships on the question of the need for a legal standard, that's because I'm saying that the applicable legal standard for the purposes of such a declaration, when it involves the question of breach or no breach, is the standard which is built into, and consciously, deliberately built into CPR 81, with all of those safeguards. So, in terms of...
The safeguards are there because there are certain consequences that attach to contempt proceedings. If those consequences don't attach to the declaratory proceedings, why do you need the safeguards?
Because this is being used as a platform for a contempt proceeding in due course in which these findings will be said to create issue estoppels.
But that's quite commonplace, isn't it? Because say you have a trial as to whether there's a breach of contract and all sorts of issues arise in relation to are the restrictions in restraint of trade, are they being breached?
Yes.
But at the end of that, the court determines that they are being breached and then injuncts the defendant from continuing to act in that way.
Yes.
Well, everything has already been determined that if they carry on, you're in breach of the injunction which is thereby granted.
Yes,
so nobody has any problem with that.
No, that's because my Lord is putting to me the example of an immediate iteration of something that's been found in civil proceedings to be a breach of contract. The question of whether, in a complex order of the kind we're looking at here, there is a breach That is to say, there's no other interpretation that I can see of the question of breach of a court order than the calumny which attaches to being in defiance of it, or however you care to put it. The word breach comes freighted. It's not a conclusion of fact. It's a conclusion of law. It's a verdict. The word breach, if you make a declaration that somebody has breached a court order, that's a verdict that that's what they've done. And you are, when you do that in the normal course of events, making an adjudication within the parameters which are built in for safeguards in CPR 81. If you wish to do something short of that, which is to obtain guidance as to whether such and such an asset is or is not an asset to which, for example, from the Ablyazov case, paragraph 9 of the order in that case applies or not, you can do that. But you're not going the extra furlong and making an order or making a declaration or an adjudication to the effect that someone has breached a court order and actually committed contempt.
It's not uncommon for parties to settle their differences by means of a consent order in Tomlin form.
Yeah.
And that will be potentially enforceable by the court. In those circumstances, one party will come back to the other, to the court and say X has breached this order and we want damages or a declaration or some kind of relief. But they don't go through the panoply of CPR 81 in those circumstances, do they?
No, but my lady, my understanding is that the provisions of a Tomlin schedule have the force of a contract.
Yeah.
And when you exercise the liberty to apply provision in the main body of the order, you're coming back to enforce the contract. It's not an enforcement of a court order. And the one thing that I've seen many times in the judgments is that the court is not imposing the Tomlin schedule on the parties. It's a consensual bilateral contract.
It's a court order made by consent, which happens to take the form of a contract, but it's still a court order.
I beg to differ, my lady. The jurisprudence, as I recollect it, is that frequently the judges have said it's not our business to even look at the contract. You can put it in a schedule. Alternatively, you can put it in an envelope countersigned by both party solicitors. That's your business. It's not the court's business. The court does not make anybody abide by the terms of the contract. It's only when somebody initiates adversarial proceedings in the ordinary way that you then have the contractual dimension, and the claim there is not a claim for breach of the court order, it's a claim for breach of the contract.
Well, surely the form of a Tomlin order is that it expressly provides that the court will enforce the terms of the order.
Exactly.
And I know some of the procedural guides expressly provide that the court must consider the terms to be satisfied that it can properly provide in the order that the court will enforce its terms. There may be terms agreed there which a court would think were inappropriate to enforce.
Well, again, I'm sorry to differ, but the practice is certainly not uniform in my experience to that effect. And my learned friend and I have just recently disposed by settlement of a case in the Supreme Court in which the terms of the agreement were not anywhere on the record, they were off the record. And the Supreme Court issued its determination of the substantive parts of the appeal on which it had nonetheless proceeded to deliver judgment, but did not purport to know or be concerned about the terms of the contract.
Oh, but that's separate. That's not a Tomlin disposition. Parties can agree to settle their differences and can say to the court, we have settled. Please produce an order by consent that we have settled, and the court isn't interested about the terms of settlement at all. But a Tomlin order is different. It's a different species. It's where the parties want the court to be able to enforce the terms of the settlement, in which case it goes into a schedule to the Tomlin order, and it becomes enforceable as part and parcel of the court's order. Even though it is contractual, it is actually embodied in a court order. And that's the difference between the two species of settlement. The settlement you're describing is not a Tomlin settlement.
I'm really sorry to find myself in disagreement, but the practice which I constantly encounter is that the solicitors will sign the agreement, they'll put it in an envelope, it will be signed by both parties, it's kept on a file and it's referred to in the body of the court order, and the court order gives liberty to apply for enforcement of the terms. But it's for enforcement of the terms of the contract, it's not a contempt provision.
I think you were correct to observe earlier that practice is not uniform in this regard. I mean, it's a while since I've last looked at this issue, but my recollection is you will find statements of principle by distinguished judges on both sides of the line. Some saying the court has no job looking at the terms of what's been agreed between the parties, and others saying, yes, the court must be satisfied that it's enforceable.
So moving forward on that basis then, I would still say that you can't enforce the, even in the example that's put against me, I'm still saying you can't enforce that by way of a committal proceeding. It's not a committal proceeding, and that's why it never happened. Shall I move on a bit?
Yes.
Right. Now, in the judgment, so we're behind tab 5, and as you know already, it's a lengthy judgment. Bear with me for a second. Yes, so on bundle page 93, behind tab 5. You have the reference to the Bank St Petersburg case, Mr Justice Hildyard. And our judge in the court below is quoting at length from that judgment, Mr Justice Hildyard. And this was a claim for a declaration that there'd been a breach of a freezing order. The judge, you can see, that's Mr Justice Hildyard, in paragraph 7 of the quotation in 54, procedural requirements for CPR 81 must be scrupulously fulfilled. Proper service. Paragraph 8. The defendants strenuously argued that these requirements have not been fulfilled, and in such circumstances shouldn't have to answer what amounts to an application for committal, even if not so called. The claimants accepted that they hadn't fulfilled all the procedural requirements applicable to such an application, but they made the obvious point that they were not seeking to establish contempt nor seeking committal. Nevertheless, to ensure a fair process, I adjourned the application over from December, and I required the claimants to set out in full the detail of the alleged breach. With those safeguards and subject to my continuing concern that the claimants do not proceed by incremental steps towards a committal application which they have disavowed, which I termed a game of grandmother's footsteps, I do not think the application should be refused on grounds of unfairness or procedural failure. However, there's an a Mackenzie man speaking to the court who referred to a case which the judge doesn't find on point. And then the judge himself, that's Mr Justice Hildyard, is speaking again in paragraph 55, paragraphs 12 and 13. The making of a declaration is always discretionary, and when considering whether to grant a declaration or not, the court takes into account justice to the claimant, and those are those famous words, and he's citing Nokia. In this case, I can see no real utility in making a declaration, even if the alleged breaches could be established, and I can see possible injustice to the defendants, if there is any possibility, as I am concerned there would be, of the grant of such a declaration being treated as if it were a finding of contempt. It was and remains open to the claimants to establish contempt and seek committal. I see no reason for or utility in the halfway house they propose. To that extent, the claimant's application fails and must be dismissed. That sentiment was echoed by Mrs Justice Diaz in a case called Invest Bank, one of the many examples of Invest Bank and El Husseini, and that was in paragraph 76 of this judgment, page 101. And you'll see the nature of the declaration that was sought there in paragraph 76. There was a worldwide freezing order. The defendant offered undertakings which the bank accepted in place of the freezing order. She's the wife. The relevant undertaking permitted the defendant to use frozen funds to pay her living and legal expenses if she had no other means to pay. The bank made an application for a declaration that the defendant did have other means to pay and for an order prohibiting the defendants from accessing the frozen funds. Mrs Justice Diaz refused the application, and her essential reasoning for doing so you can see quoted in paragraph 77. So you have the submissions of counsel before Mrs Justice Diaz. The bank wasn't seeking to bypass the law of contempt. He said a determination based on the civil standard of proof couldn't possibly prejudice Joan in relation to any potential contempt proceedings, particularly if it was incorporated only in a recital as proposed. He further said that there was no abuse. All that the bank wanted to do was to clarify what exactly was meant by the undertaking. This, he submitted, was squarely within the court's ancillary jurisdiction, and it was unattractive to argue that the bank had not been entitled to bring the matter back to court. Inevitably things change, he said, and it cannot have been intended that the bank could be precluded from returning to seek clarity. On this point I am quite clear that it would not be appropriate for me to make any determination one way or the other as to whether Joan does or does not presently have other means to pay, still less any determination which purports to be final. I say that for the following reasons. First, it seems to me that I'm in precisely the same position as Mr Marlock was in January. The evidence before me is substantially identical to the evidence that was before him. There's been no disclosure, no cross-examination. For the reasons he gave, it would be wholly inappropriate to attempt to make any finding. Secondly, this would be exactly the sort of halfway house deprecated by Mr Justice Hildyard in the St Petersburg case, which is capable of causing prejudice to Joan. Even if I only make a determination on a civil standard of proof, I would effectively be making a finding on untested evidence in circumstances where the primary sanction for breach of a voluntary undertaking is an application to commit with all the concomitant safeguards that entails. In my judgment, it would be wrong in principle to do that without giving both sides an opportunity to test the evidence by cross-examination in the light of disclosure. Thirdly, in any event, such a determination would be of no practical utility whatsoever. The bank has said it would undertake not to apply to commit for past contempt, but in that case, what is the purpose of the proposed determination? Any determination I make could only apply to the situation as it exists today. That might change tomorrow, or next week it might change back again thereafter. The prospect of precious commercial court time being taken up with serial applications to determine the position every time Joan wished to spend money is not one which can be consistently with the overriding objective. Now, there are other cases. Notably, the judge has mentioned a case which is very vivid to me, which was the Amstrad case, in which the Court of Appeal in 1986 declined to grant declaratory relief, even though all the civil arguments in the case had been won by my side, and there was unanimous judgments to that effect. But because there was a possibility that was not even a live possibility that the conduct in question in that case might be the subject of a criminal prosecution at some stage or other. And the Court of Appeal declined, having gone through all of the arguments on civil liability and rejected them, declined to grant declaratory relief. Now, on this question of maintaining the demarcation, as I'm going to call it, maintaining the demarcation between CPR 81 and CPR 4020, may I just refer you back to our skeleton. Please bear with me for 1 second. So if I can please pick it up at paragraph 24 of our skeleton, which is on page 28 of the bundle. On paragraph 24, we note, and there is in fact a solid body of authority at appellate level for proceedings which involve questions of contempt to be determined separately from proceedings at trial or any other application or civil claim. And there's a whole series of cases there. The one that we selected for inclusion in the bundle is Re L, which is very robust on that subject. I won't take time going to it, but it's clear for the proposition that you should not mingle civil and civil procedures and the quasi-criminal procedures associated with contempt. The halfway house point is noted in paragraph 25, and I've identified the authorities there. There's one I haven't taken you to, but that's in the bundle, which is the Bus and Coach Association. That was a two-judge divisional court. Lord Justice Leggett and Mr Justice Lewis, as I recollect, yes. And those cases there also stand for the proposition that you shouldn't be engaging in halfway houses here. And in this connection, we have an article in the bundle which is written by, well, it's not an article, it's a section of the book on judicial review written by Lord Justice Lewis. And I wonder if I might show you what that says. It's in bundle A. And it's behind tab 12. Edition 2021, and on bundle page 211, declarations in the criminal law, paragraph 7-053. The courts have had to consider the appropriateness of granting declarations in civil proceedings as to whether particular conduct would or would not be a criminal offence. The courts have jurisdiction to grant a declaration that certain conduct is or is not lawful, and the question is whether it's appropriate for them to exercise that jurisdiction. In general terms, the courts are reluctant to grant such declarations in civil proceedings, including claims for judicial review, except in exceptional circumstances. No clear pattern of what constitutes exceptional circumstances or what criteria are relevant in determining that question emerges from the case law. We've sidelined a section of paragraph 7055 on the next page, which makes the point that the courts are unlikely to be prepared to grant a declaration where the case is fact-sensitive, in that the outcome may depend on the view taken of the particular facts. This factor is of great importance, and it's always been recognised that a question of pure law may be more readily made the subject matter of a declaration. To the top of the next page at 213, we've sidelined at the top, the court should be particularly cautious of granting declaratory relief in relation to existing rather than future conduct, and should be warier of granting a declaration that particular conduct is criminal rather than that particular conduct would not involve the commission of a criminal offence. If the court granted a declaration in respect of existing conduct, it would be performing the task of the jury. If it declared that certain conduct was not criminal as a matter of law, it would be performing the function of the judge in deciding there was no case to answer. Further, the courts are reluctant to stigmatise the conduct of particular individuals as criminal, and are more likely to be prepared to grant a declaration if it involves a declaration as to the interpretation of particular statutory provision without the need for consideration of the actions of particular individuals. 7056 at the bottom. There have been occasions when the courts have exceptionally been prepared to entertain civil proceedings, notwithstanding that the proceedings involve determining whether conduct is or would be unlawful. In general, these cases involve a recognition that a real or cogent public interest is served by dealing with matters in ordinary civil proceedings. In one group of cases, the courts have been prepared to grant declarations on questions of law or statutory construction where there was a real need to do so, and this could be done without granting declarations that particular conduct by individuals would contravene the criminal law. So you have a position which is emerging there. I don't need to refer you to more, although we've sidelined more there. So I make my submission, as I foreshadowed. The policy of the law is clear in my submission. It's not the policy of the law to have a halfway house, as I've called it several times using the language of the case law. On this, as I've said already, there should be no mingling of civil and quasi-criminal procedures. And as you've seen from the extract I've just shown you from Lewis's, Lord Justice Lewis's book on administrative law and judicial review, a declaration that something has or has not incurred criminal liability is truly exceptional, or should be truly exceptional. In other words, it's not the norm. Now, that is what I say is the consequence of respecting the legal standard which is applicable, the legal standard test which is applicable to the grant of declaratory relief. The legal standard is brought into play by the nature of the declaration that's claimed. If you don't claim that there's a breach, then you haven't claimed a breach, and then the court will have to look to see whether you've done something short of it, which the court can properly entertain. But if you're going to go the whole hog, as I called it, and request an adjudication of breach of a court order, then you have entered into the realms in my submission of CPR 81 and all the safeguards. And it is it's nothing to the point that the claimant offers an undertaking not to invoke any of the adjudications for past conduct in proceedings for contempt. What a disclaimer to that effect does is actually acknowledge the problem. You would not need to have a disclaimer if you weren't already overreaching into the realms of CPR 81. It's like a disclaimer in a trademark or passing off case. These goods have nothing to do with X, Y, Z. The only reason you need to say it is because there's a risk that they do. Now, then there's the question of discretion and utility. So even when you're into the realms of where you think it might be an appropriate case to grant a declaration that someone has breached a court order, there's the question of utility, usefulness, and so on and so forth. Now, you've seen already enough to know, depending on how you count them, there's 50, 53, 54, you can count them in different ways, but there is a plethora of incidents which have been identified for the purposes of declaratory relief. And what do they have in common? The only thing they have in common is that they're completely miscellaneous. So there was a question which we say the judge ought to have addressed at the threshold of this, which is when we asked him to make declarations that went to the construction of the order and what it did or didn't embrace, as we've modelled in our box 9 in our grounds of appeal, notice of appeal. The threshold question, he went on to do it, is whether he should in fact have gone through all 55 instances and made a determination of breach or no breach for each. So, in doing so, he was not engaging in an assessment of any policy decisions. Nothing called into question administrative arrangements that were in place in my client's company. What did they resolve? What did the declarations resolve? They only got rid of arguments about whether Mr. X or Miss Y took some accidental step or not on some occasion. They don't have the intrinsic character of something educational, and equipped with them, and you notice how it came out, half of them went, say half went to my opponents, in my opponent's favour, half went in my favour. And you could spend hours at a later hearing, if there ever was one, debating whether what you were looking at the later hearing was or wasn't closer to some one of the myriad incidents which had been dealt with in this judgment, or another one of them, or several of them, or what. They didn't have any educative effect. They had no more effect, the declarations, than to adjudicate upon a particular incident on one occasion, on an isolated occasion, and they didn't, in the form in which the declarations were made, actually grant declaratory relief on the meaning and construction of the order at all. You have to read the narrative portions of the judgment in order to find out what the judge was saying the construction was. Whereas in the form that we proposed in box 9, we've put forward declarations for consideration which do address what we see as understandably the key questions of construction of the order. Now, unless my lords and my lady wish to press me further in relation to that first branch of the appeal, I will move to the second branch of the appeal. Right. Now, in our skeleton, this is covered by paragraphs 41 to 78. The nub of it is that the case that went to the Court of Appeal, the case started in 2013. There was a judgment of Mr Justice Norris in 2016. It went to the Court of Appeal in 2017, and remitted issues came back to Mr Justice Norris in 2018. We adduced unchallenged and uncontroverted evidence that the factual position with regard to the websites and social media presences had materially changed since those events which had given rise to the final judgment, the ultimate final judgment. And it's important, I think I should mention, that the final judgment is dated 2020. It was delivered, because the judge had been unwell, it was delivered approximately 23 months after the conclusion of the remitted hearing. The remitted hearing took place in July of 2018. The world had changed, the organisation of my client's business had changed. We provided evidence of that, and as I've said repeatedly, it was unchallenged and uncontroverted, and it mattered. Now, the judge did not anywhere that we can locate mention that really important element of the assessment. The judgment, the case which had come to a conclusion before, the causes of action associated with it had merged in the judgment, had merged in the order. You can't go back behind it, but it doesn't mean that the situation which was the subject of the adjudication and embodied in the order was perpetuating or being carried forward, or that the answer to the problems which came up later in the disagreement between the parties are to be found in the earlier judgment. That's not an assumption that could properly be made in the circumstances of this case. Now, I'm going to show you in a short while some passages in the remitted judgment which serve to explain how it was that Mr Justice Norris, I think he was still Mr Justice Norris at the time, how Mr Justice Norris came to the conclusion he did that the test for targeting and infringement of registered trademark was satisfied on the facts before him. The ingredients of liability for trademark infringement revolve around the concept of using, and that's a somewhat technical term, but anyway, it is interpreted technically, it has a specific meaning, using a trademark in the course of trade in the UK. And use means use for the purposes of distinguishing. Classic trademark.
We have to be careful though, because of course we've also got the contract.
That's true.
Claim and paragraph 2 of the order, as well as the trademark claim and paragraph 3.
It's true. The judge said the test for targeting is the same for both. He made that clear because use within the jurisdiction is required for both. Use within the UK is built into, several times over, built into paragraphs 2 and 3. But I'm concentrating, I moved to a point that I'm particularly focused on following the Amazon and Lifestyle Equities case in the Supreme Court, which is the requirement for use in relation to goods and services in the course of trade in the UK, and that's a composite requirement. Now, the two, use for the purposes of distinguishing means use so as to create the impression of a material link between the goods in question and the mark, thence to the user of the mark. And the case law most recently has been summed up clearly, most recently in the judgment of my Lord Justice Arnold in the Montreux-Breguet case. Use for the purposes of distinguishing means use as a trademark. Now, there are two strands operating like strands of, like the helix, the DNA helix. There's the modality of use, and there's the territoriality of use. The territoriality of use is all-pervading. So when we talk about the purposes of distinguishing those other factors I've just identified, they're about the modality of the use. And still, however, you must come to the conclusion that there is use in the course of trade in the United Kingdom in relation to goods or services. Now, it is always said, it's axiomatic, but it doesn't take you very far, but it's always said, it isn't sufficient to say that, it's always said that mere accessibility is not enough. All websites are in principle accessible from everywhere in the world, and that is not enough to give rise to targeting of a kind which can be found to be infringing. And I go further. The reason it's not enough is because you actually need a positive finding on those ingredients that I've just identified. It is common ground, and it always has been, that the US website provides no goods or services. You can't buy anything through it or by going to it. And the issue has always been, in the past and now, how is it then that you can satisfy the requirement for use of a mark in relation to goods or services within the territory of the United Kingdom? It's been said many times, targeting itself is not sufficient, targeting is not a tort, targeting is not liability, but those are just all straws in the wind relative to the basic requirement for a positive finding that there has been use within the jurisdiction. Now, I'm going to show you, if I may, how Mr Justice Norris dealt with this when the matter was remitted to him by the Court of Appeal. And for that purpose, I need, if I may, to take you to this core supplementary bundle. His reserved matters judgment is behind tab 4. And within that judgment, if I may, page 166, is paragraph 24. This is in the question, on the question of infringement, because it's pre-Amazon in the Supreme Court. You'll see the reference in paragraph 24. It's one of a multiplicity of references in the judgments which have gone before to a suite of global websites, some with UK-specific content to support and promote its business. And then there's a long list of them. Then there are media activities. And his lordship observes that in the last sentence of 24, these are findings made at trial that withstood the challenge on appeal. What he's referring to there is that his judgment in relation to trademark infringement was reversed on appeal and set aside. It was remitted to him with the guidance that the Court of Appeal had provided in Merck in the Court of Appeal. And he's making the point that those findings that he made withstood the challenge on appeal. And what you're looking at there, in that language of a suite of global websites, is a sort of web. Now that's important because when you're talking about the internet which knows no boundaries, it certainly doesn't correspond to geographical or state territorial boundaries. If you have a web of websites operating in that way, then you already have a situation in which they are interlocked and overarching, overreaching. Judge says at 26, the issues that fall to be determined are difficult, turn on matters of detail and broad context. Can I take you to 27? It is not in dispute that the only use of which Merck Global can complain by way of trademark infringement is use by Merck US of the sign Merck in the UK in the course of trade in relation to goods or services. Pause there, that's what I've called the modality of the use. Nor in these proceedings is it in dispute that Merck US has never sold or supplied goods or services in the UK under or by reference to the sign Merck. Goods or services are sold or supplied by MSD. Could you note that, please, because it's material to what he then goes on to say. The use of which complaint is made is of the use by MSD and by Merck US of Merck in promotional and informational material and in the course of general commercial activities. Notice the use of the word and. It's used by MSD and by Merck US. That is fleshed out. His Lordship refers back to the concept of use in the course of trade, which was obviously dealt with at some length in the Court of Appeal in Merck. And he refers to two paragraphs from the judgment of Lord Justice Kitchen. First, the expression using in the course of trade any sign in relation to goods or services means use for the purpose of distinguishing those goods or services from those of other suppliers. Secondly, and equally importantly, the expression also means use such as to create the impression that there is a material link in the course of trade between the goods or services concerned and the undertaking from which those goods or services originate. So you see the they're interrelated concepts for the purposes of distinguishing, and then the material link is, what shall I call it, an aspect or dimension of that. Judge says the focus in this case is upon the second of these meanings, material link, and that's certainly the focus of where he's going from here. Even if a sign is not affixed to goods or services, so that's meaning it's not on the label as such, that are marketed, there is use in relation to goods or services if that sign is used in such a way as to establish in the mind of the average consumer a link between the sign constituting the company or trade name and the products or services provided by the third party. He's summarised. Just to dwell on that point a little, what has to be established here is a link between A, the sign constituting the company or business name of the defendant, and B, the goods or services marketed by the defendant. And if that link is established, then there is not simply use of the mark, but use in the course of trade in relation to goods or services. The sign is not just the name of the business, it's also an indicator of origin. Thus, the unauthorised use by a third party of a sign which is identical and so on must still be shown to affect the essential functions. Now, can I turn the page? Merck Global's submissions are recorded in paragraph 30. He then addresses and answers my submissions in paragraphs 32 to 35 primarily, but there are later paragraphs, 32 to 35. Now, could I ask you to note at this point that the judge in our case in the court below refers back to this judgment. He doesn't actually dwell on the important detail of what the judge himself said about this submission in the course of the remitted issues judgment in the suite of website worlds that he was dealing with. So I've submitted that the focus lay elsewhere. The establishment of a link was but just one part of the composite process, and that in the present case the key issue was not the nature of the link, but whether there was use of in the course of trade in the UK. He quotes from the Court of Appeal, and it's absolutely right. There's no dispute about the law being as quoted there. The argument of Merck, he recites, is that it never had any trade here, no customers, no services, and so on. He notes the argument, if you don't have goods hypothecated for marketing within the UK, you don't have use in the course of trade. There's a reference to a case called Blomqvist, another case called Rio Glass, which I will show you shortly if I may, Glass International, L'Oreal and Phillips. You do not have use in commerce is my submission in that way. Goods hypothecated for marketing within the territory, you don't have it in the United Kingdom. Now, the judge answers this in paragraphs 34 and 35 in particular. In 34, he makes the point that if this argument was a complete knockout, the Court of Appeal wouldn't have remitted anything for him to decide. So he's saying, the Court of Appeal has left it open to me, left open the possibility that use in the course of trade in the UK is not confined to situations where Merck US or MSD was selling or offering for sale hypothecated goods, but covered situations in which they were indulging in some other material and relevant commercial activity with a view to gain. In 35, he puts an example to me. Suppose all goods were sold under the MSD name, but there is packaging or advertising that says MSD made by Merck. Counsel acknowledged that that would be a classic trademark use. Now suppose that the goods are sold under the MSD name, but MSD and Merck US are anxious, not by labelling on the box, but by other means, to establish in the mind of the relevant consumer that the MSD goods are made by or under the control of Merck. Would that constitute use in the course of trade in the UK? In principle, I think it's capable of doing so. It might be that MSD and Merck US decide upon a business model that has the consequence that MSD, which has the vendable products or services, is associated at every opportunity with Merck, so that a link is formed in the mind of the average consumer between MSD and the business carried on by Merck US under the Merck mark. And you can see what is coming. The hypothecation that I said was missing, the judge goes on to find that there is a network of sites, the operation of which leads to the situation that he's outlining there in paragraph 35, whereby the US Merck is, as it were, overtly presenting itself as being the entity that stands behind the MSD goods. And of course the MSD goods were sold in the United Kingdom, the goods were here. Now, to press that home just a little bit, if I take you to paragraph 43 in particular, in the end of it, but 43, the judge is working his way through the samples that were put before him for adjudication, and he's reviewing what is the second sample. But could you please notice the last 4 lines of paragraph 43 on the top of 172? So what's happening in the judge's view is that because of the way the suite of websites, etc., is operating, you're finding use in the course of trade in the UK relative to goods which are MSD goods, relative to which the Merck US company is linking its Merck brand. So there's the link. And again, you'll see at the last 3-4 lines of 46, he says the same thing. It's used in relation to trade because its use is designed to associate in the minds of the reasonable consumer goods and services provided by MSD in the UK with the Merck sign, and to promote that business by establishing appealing brand values, and objectively it has that effect. So stepping back, on the requirement for use in the course of trade in relation to goods or services in the UK, last time around, because of the way the whole of the suite of sites was structured, the judge found on the evidence and materials before him, which goes back to 2015, 2016, because the evidence was carried forward for the remitted hearing, he finds on that evidence that there is in fact a link operating cross-border between the American company and the goods in the United Kingdom. There is absolutely no way in which that business model which gave rise to that finding can be said to be subsisting now. We told the judge that it had all changed. He didn't refer to it in his judgment, the evidence which I've called unchallenged and uncontroverted. He didn't refer to it. And he felt able, by dipping back to what Mr Justice Norris had said, he found it possible to say that there was, I suppose I could call it similar-ish or effectively the same sort of use occurring here this time around. But there wasn't. Always the question is, where are the goods and services? And you can't find them. In the judgment, as I anticipate Mr Hollingworth will show your lordship shortly, in the judgment he doesn't identify goods or services in the course of trade, in the UK in the relevant sense. Where are the customers? He doesn't identify any. And the reason is that he can't. And he can't because there weren't any, because the model has changed to the point at which my clients don't have the footprint, if I can call it that, which led to the finding of infringement last time round. If I may then, I'll show you where the judge, forgive me 1 second again, sorry. I need to be behind tab 5 in the court bundle to find the judge's judgment. What did he do with this guy? Yeah, please. Say again.
205.
No, that isn't what I wanted. I'm sorry, my lord. I've lost the reference that I wanted. No, I haven't. Page 128 to 131. On page 128, he's reminded himself entirely correctly of the composite expression that I've addressed you on several times, in which you will know already anyway. 178. It's important to note that the question of infringement of the claimant's trademark was considered by Sir Alistair at some length in the remitted issues judgment. If I can allow myself the comment, it was important to note that in order to appreciate that there was evidence that we had adduced that the situation wasn't the same or anything like it. Now, he then quotes from the judgment, and that's Sir Alistair's judgment, and you'll see he starts with paragraphs 24 and 25 and quotes them at length. He then quotes, in his paragraph 179, he quotes Sir Alistair's paragraph 27, and I showed you that. And then in paragraph 180, he goes through the argument. As I understand the position, he says, fourth line of 180, it remains the case that Merck US have never sold or supplied goods or services in the UK under or by reference to the signed Merck. Such goods or services continue to be sold or supplied under the MSD brand. The only reference, if you see at the end of paragraph 180, to the paragraphs that I have just emphasised to the court, paragraphs 32 to 36, in which I explained precisely how the judge had come to the finding of a link between US Merck and the MSD goods. All he does is refer to them as 32 to 36. Those are the paragraphs which I stressed with a few more on top. That is the sum total of his reference to the crucial point on which Sir Alistair based his judgment last time round. And what's crucial is that that is not the situation which was obtaining in the judgment, in the situation that was before our judge in this case. And then there's another, I would say before Mr. Hollingworth speaks, a slightly ominous thing on paragraph 212. In the judge's judgment on page 136. This is a discussion about the use of an @merck.com email address. He says there's confusion here. I can see that there are various issues to be resolved in relation to the question of whether the use of the relevant email addresses constituted a breach of paragraph 3, that's the trademark injunction, including the question of whether this constituted use of Merck as a trademark. If, however, it is assumed that the use of these email addresses did constitute use of a mark as a trademark in the course of trade in the UK, this necessarily assumes that these email addresses were being used to promote some goods or services of Merck US. If this is assumed to have been happening, I have some difficulty in seeing how these goods and services could not possibly be at least similar to the goods or services of Merck Global, which are specified in the annex. Now, this is putting the cart before the horse altogether. You can't assume that. You can't.
It's not saying that you can. This is all about the question of similarity of goods, which is not a ground of appeal.
No. But the judge is not. Mr. Hollingworth was submitting in relation to what at Merck was being used in relation to in examples, right? And the judge says, if I assume that it's being used in the course of trade in relation in the UK, then that carries with it the finding that the goods or services with reference to which it's being used are identical or similar. I agree that's what he's saying in the second half of that. Our point is that you can't do the exercise by assuming that it is being used in the course of trade. The question is whether it's being used in the course of trade in the UK in relation to goods or services. Only then do you get to the question of whether they are identical or similar. Now, we have identified at length the passages from Amazon in the Supreme Court that we wish your lordships to have in mind. I'm not sure, in fact I'm fairly sure that unless you want me to, I don't think there's anything to be gained by me taking you to those passages. They're there, we've quoted from them. They're there to be seen, and it's all sidelined in the bundle. So we've drawn attention to what we say matters. Now, on the question of use in the UK, in that connection, could I take you to our skeleton? Page 36 in the stamped pagination, we identify the portions that matter for our case anyway. In particular, we refer to what the Supreme Court accepted from a case called Hammer. Hammer makes it clear that, amongst other things, simply providing an email address and other contact details isn't targeting, isn't getting you to the situation in which you're going to be even potentially liable for trademark infringement. We've cited the passages from the Supreme Court which say that the exercise must be, if I can call it that, holistic. The appraisal must be holistic. Paragraph 62, we've identified the journey. The journey has always been a very important part of these cases. Metaphorically speaking, as Mr Justice Jacobs said in the case of Euromarket Designs and Peters, that's noted at the end of 62 and it's in our bundle, you're visiting. You're visiting. If you know you're visiting a foreign website, you are going there. And if you go through, as the evidence will show, you go through a pop-up which says you're going to a site which is intended for residents of the United States specifically, you are undertaking the equivalent of a journey that passes through a sort of immigration control procedure whereby you have gone there. It has not come to you, you have gone there. And insofar as you've learned about it in some way, shape, form or another, you are being told, and this is a very familiar mechanism on the internet, this is not for you. There are any number of activities on the internet which employ similar such mechanisms. The financial services products, notably, where it says, are you a broker? Who are you? If you're a consumer, don't come here. It's a very familiar way of creating, if you like, a border over which the internet user passes and crosses on his journey. And that's really important because the internet itself doesn't have such borders, but you can, by means of these mechanisms and devices, you can in fact create an electronic equivalent of them. An example of the pop-ups, which will be discussed with you, you can see in paragraphs 66 and 67, but you'll hopefully see it in real life shortly. In the Supreme Court, it was a major factor in the finding. In fact, it could have been conclusive on the finding, at least on the journey, that the pop-up said that you were going to be able to get goods which were going to be available for shipment to your country. In our case, we have pop-ups, and the text of them is quoted as best you can do it in 67, but you need to see it in the flesh. Welcome to Merck.com. By continuing, you will be directed to a site intended only for residents of the US and Canada. We are called MSD everywhere except in the US and Canada, where we are known as Merck and Co. Kenilworth. That wording is in the court order as satisfactory for the purposes of a link between MSD sites and US sites. It was framed after argument and discussion as to what would be an appropriate warning of the fact that you are visiting a site for US residents. And the judge gave no weight to it. In his analysis, as you will see, he gave no weight to it. And yet it's crucial. So not only do we have nothing like the suite of websites that gave rise to liability last time round, we have pop-ups in play, and the judge notes them where he does note them. He doesn't always note them, where he does note them, and he pays no weight to it, gives it no weight. Now, may I turn you in my skeleton to page 40, and this is, from where I'm standing, this is an important point. It's an important point that is still waiting to be firmly decided. So I pick up in paragraph 74, which by now you will have seen tediously mentioned and re-mentioned.
Can I just ask about what you importance of this question is in the present case. Because, correct me if I've misunderstood, but my understanding at the moment is that on the judge's judgment, all the findings of breaches of paragraph 3 are a subset of findings of breaches of paragraph 2. Therefore, even assuming you prevail on paragraph 3, it gets your clients nowhere if the findings of breaches of paragraph 2 are sustained.
I wouldn't say it gets me nowhere when I've got a declaration that I've breached paragraph 3, my lord, specifically.
How does it help you if the declaration of breach paragraph 2 stands?
First of all, I shouldn't be found to have breached paragraph 3, and secondly, the question of whether there is targeting as a threshold sufficient for 2 is also a question of targeting sufficient for paragraph 3.
Targeting applies to both, but the point you're making here, as you say in paragraph 72,
yes,
to which you've just drawn attention, is specific
yes,
to paragraph 3.
Yes, it is.
So I'm still waiting for an answer to the question of what is the practical purpose of setting aside findings of breaches of paragraph 3 if breaches of paragraph 2 remain.
It begs the question as to whether the paragraph 2 breaches remain when you've done the exercise.
No, that's the hypothesis I'm asking you about. Obviously, if paragraph 2 goes, then this becomes a potentially important issue. But I'm asking you to assume for the purposes of my submission, and this is an assumption, I appreciate full well you're attacking breaches of paragraph 2 as well, but let's assume for the purposes of the question that you're unsuccessful on that. And the question then is, why is not the issue regarding paragraph 3 academic?
It's not academic because if anything is to be learned from the judgment going forward, I need to know whether I'm on the right side or the wrong side of paragraph 3, whether or not I'm on the wrong side of paragraph 2. I have to know both, because in future there will be conduct, or there could be conduct, I don't want to say there will be, there could be conduct relative to which paragraph 2 has no operation.
So, do I understand you therefore to be submitting is that the reason why it's not academic is the parties need to know where they stand going forward?
They need to know how the provisions are to be construed relative to the matters which we've raised for consideration in that connection. Yes, my lord, yes. And paragraph 9, to refer back to it, of my notice of appeal, box 9, has declarations directed to these matters. And please bear in mind that in every one of these instances, it's a consolidated, coherent thing. In other words, it's an event. The judge analyses the evidence. He then comes to a conclusion on 3. He then comes to a conclusion on 2.
Right. So the point comes to this, that it is of utility for the court to determine the ambit of paragraph 3, even if it makes no impact with regard to the specific acts in the past which were alleged and found to constitute breaches.
I understand the point of the question, and my answer is yes, provided it, and I'm back to my first main strand of appeal, provided you approach it in the correct way. And we say that in those models that we put forward for declaratory relief in box 9, we have done that. We say we have done that. The other side have made no attempt to do anything that drops short of a declaration of breach. And the point that my lord has put to me is identifying how straightforward, if you put your mind to it, it can be to isolate a question of interpretation on the order and to seek guidance by means of declaratory relief in relation to it without going what I've repeatedly called a whole hog of demanding that someone be held to have acted in breach.
Okay.
So I'm on page 40, and I just stopped at paragraph 74, and then we draw attention to what's in paragraph 72 in the Amazon case. So there was a pop-up. It informed consumers that the goods they were about to be shown were available for delivery in the UK. And the Supreme Court concluded that paragraph by observing that in this context, it must be assumed that the US branded goods were designated as items that shipped to the UK. If they were not, then the case for targeting would of course fall flat on its face. Now that's really, from where I'm standing, an important point in the whole of this area of the law about website, internet targeting, internet use in the course of trade in the UK. We say that that statement at the end of 72 in the Supreme Court chimes with existing jurisprudence, which we go on to identify in 76 and 77. If I'm pronouncing it correctly, AMS Neve, or Never, I'm not sure, Neve I suppose, we take you to a footnote 12 where we quote from what the Court of Justice ruled. And the point about that ruling is that the supplier does not have to be present in the jurisdiction. The goods or services don't initially have to be within the jurisdiction. The server doesn't have to be in the jurisdiction, etc., etc., etc. But what does have to be in the jurisdiction is the marketing to the consumers in the jurisdiction concerned. So there has to be a setting in train of a process from which it is apparent that goods or services which have been identified on a website for sale or supply to consumers within the territory, that there's a process which will result in those goods being delivered or those services supplied to people within the territory. And you can't get away from it. The basic principle was long ago stated in IHT Ideal Standard, and it's in the italicised sentence at the end of 76. National law can only provide relief in respect of acts performed on the national territory. It doesn't mean they can't have their inception outside, but you've got to be performing acts on the national territory. And then the case law is solid in 77. You don't, and many of those are customs cases. In fact, no, they're not all customs cases, but many of them are. Customs is the equivalent of a foreign country when the goods are still, as we used to call them, in bond. It's the same as a foreign country. And in order for goods which are in bond to be capable of being, dealings in them to be regarded as infringing, you have to show that there's a course of conduct and offering for sale of goods or services that necessarily entails putting them on the market in the territory covered by the relevant trademark registration. If you don't have that, you don't have an infringement situation. Now, those cases are cited, they're well known. The one that isn't a customs case is Dimensioni Direct Sales, that was a copyright case. That case, by the way, explains the Blomqvist case, which the Supreme Court decided was opaque, shall I say. The Blomqvist case is actually quite straightforward if you think about it. The Rolex watches were supplied, I think it was from Hong Kong directly, by way of trade to someone who was engaged in trade, I believe, in the UK, or no, Germany or wherever. It's a clear case. Now, the case I would like to show you, it's short and to the point, and in my submission, it's always been correct. Could I take you, please, to the Rio Glass case, which is in Bundle A. Tab 3. The goods were in transit. on their way from Spain to Poland. Poland wasn't at that time a member of the EU, and there was a detention by French customs authorities on the grounds of trademark infringement or suspected trademark infringement. The question in the case is identified at the bottom of stamped page 50. Is Article 30 of the treaty, now Article 28, to be interpreted as meaning that it precludes the implementation, pursuant to the French Intellectual Property Code, of procedures for detention by the customs authorities of goods lawfully manufactured in a member state, which are intended, following their transit through French territory, to be placed on the market in a non-member country, Poland. And the court, in pertinent part, for my purposes, deals with this on page stamped 55. Paragraph 24. According to the judgment for reference, the goods in issue in the present case were detained on suspicion of infringement of trademark. With respect to trademarks, it's settled case law that the specific subject matter of a trademark is in particular to guarantee to the owner that he has the exclusive right to use that mark for the purpose of putting a product on the market for the first time, and thus to protect him against competitors wishing to take unfair advantage of the status and reputation of the trademark by selling products illegally bearing it. Then you get this in 26. The implementation of such protection is therefore linked to the marketing of the goods. Transit, such as that in issue in the main proceedings, which consists in transporting goods lawfully manufactured in a member state to a non-member state by passing through, does not involve any marketing of the goods in question and is therefore not liable to infringe the specific subject matter of the trademark. Furthermore, paragraph 28, as the Advocate General noted, that conclusion holds good regardless of the final destination of the goods in transit. The fact that goods are subsequently placed on the market in a non-member country and not in another member state doesn't alter the nature of the transit operation, which by definition does not constitute placing on the market. Now,
so these principles, as you said earlier, are well established, but what's the relevance to the present case where we're not concerned with goods in transit?
No.
We're concerned with advertising, including advertising of services.
Yes, but first of all, picking up the last point first, advertising is one means by which you can, but don't inevitably, engage in use of a mark in the course of trade in relation to goods or services. It doesn't water down the requirement, it just refers to one of the modalities by which you might achieve that end result. But what there was the last time round in this litigation was marketing within the United Kingdom in which the MSD goods and services were linked by means of the branding to the US Merck mark, as Sir Alistair held in those paragraphs I showed you. You had the requirement for marketing in this country satisfied. Now, you don't have it here. And as far as I can see, the judge hasn't found that you have it here. I can't find in the judgment below any statement to the effect that there was marketing of goods and services in this country to which the Merck mark was applied. It hasn't happened. And that's because we've changed all our procedures. Now, as I say again, it isn't necessary for the supplier to be present here. It isn't necessary for the goods initially to be present here. It's not necessary for the service to be supplied instantaneously to the UK, and so on and so forth. And indeed, there's a case which is the standard hotel case, in which the use on the internet involved taking bookings for a hotel that was outside the territory of protection. You have to have customers here, and they have to be addressed by way of marketing in connection with the supply of goods or services to them, here, to them as consumers. And this is constantly overlooked in the case law. there is insufficient emphasis on it, and what I'm really seeking to achieve is recognition of it, and recognition that in the last sentence of paragraph 72 of the Supreme Court judgment in Lifestyle Equities in Amazon, that sentence is meaningful and relevant for all internet targeting cases. Now, my learned friend, Mr Hollingworth, will, with your permission, address you further to flesh this out with examples from what was before the judge, so you can see for yourselves. Unless there's more, I won't add to what's in my pattern on the second point. I will go to the third point, if I may, which is the order and the construction of it.
Certainly.
Thank you. Now, this is dealt with in our skeleton in paragraphs 79 to 103. I will call, I think it's best if we have the order up, open in front of us at this point. So it's in bundle 5, and it's in a slightly, it was attached to something else, so you'll find it in behind tab 10. Say again? Bundle C. Did I not say bundle C? The core bundle. The core bundle behind tab 10, and the order starts at page 223. The order, as you can see, is dated the 28th of July 2020, but as I've already mentioned to you, the hearing itself finished in July 2018. It was around about July the 4th. Now, the operative parts you can find on page 226. The injunction at paragraph 2 is directed to the scope of clause 7 of the agreement, and it's in terms which specifically proscribe use within the United Kingdom. So there's it's the same common threshold requirement for being present within the United Kingdom in electronic form, if you like, of the trademark Merck. So you notice that that's how paragraph 2 runs over into paragraph 3, of the trademark Merck, and or be the word Merck as a contraction of its corporate name or as a trade or business name. So those are two distinct limbs linked by the expression and or. And then the further provision in the tailpiece, when furthering or promoting its business to third parties. So you have a commonality here between 2 and 3. You're looking to see whether there's use within the United Kingdom of the trademark Merck and or the word Merck when furthering or promoting its business to third parties. But the locus of this, the subject matter jurisdiction, shall I say, of it, is use within the United Kingdom for that commercial purpose. And then at 3, the defendants in each of them. Now, the reason that paragraph 2 is framed in that way is because it's only the first defendant that is bound by the contract. The others are not bound by that contract, and that's why the injunction on clause 7 goes only against the first defendant. Then at 3, the defendants in each of them shan't infringe the UK marks by using the sign Merck as a trademark in the course of trade in the United Kingdom, and that follows the language of the statutory requirements that I've been addressing you upon. Then you have the opening words of 4. It shall not be a breach of paragraphs 2 or 3 of this order. A preserves everything that's authorised and permitted by that agreement, which was restated in 1970, having been made in 1955 originally. It's the same agreement with a minor change in 1970. B, which is in issue, for the defendants to establish and maintain any MSD branded UK specific websites. And the bone of contention is what is meant by UK specific websites. You'll notice that it doesn't use any top-level domain name suffix. It doesn't say any msd.co.uk or msd any other dot whatever, dot uk whatever. It doesn't say that. It says any MSD branded UK specific websites. The judges interpreted this as meaning UK specific, exclusively UK specific as a website, and not one within the footprint of which the UK is, if I can put it that stilted way. We say it doesn't mean that. We say there isn't such a thing as a UK specific website in that sense. It's impossible to conceive of a website that, for example, was addressed to people in the United Kingdom that didn't also come to be addressed to people in Ireland, for example. The footprint of a website is as broad as people can get to it, but if you take into account targeting, we say the correct interpretation of that is that it means a website within the footprint of which it can be said it is targeting the UK. Not the UK exclusively, but the UK. And remember, this is operating...
So that would make the Amazon.com website UK specific.
Well, actually, I was surprised not to see that argument actually run, because the way I lost in Merck, as I've showed you, was the web of sites. I was very surprised to see that that argument wasn't run in Amazon, and the case was dealt with, if you like, on hermetically sealed geographical terms. But I'm not prepared to say that they couldn't have argued that and succeeded on it. My point is I'm dealing with my order in this case and the specifics of what I'm looking at. It may well have repercussive effects on other cases, and Amazon could be a good example. But I'm not going to go there because it's not my business to go there. But why do you need... I'm sorry, it's impertinent. I've got an exclusion at B. What is the exclusion in relation to? It's in relation to what would otherwise be a website that is sufficiently targeted for the purposes of 2 and/or 3. Why shouldn't, I ask respectfully, why shouldn't the exception be as broad as the bane to which it is the antidote? So my submission is it's actually meaningless to speak in technical terms of a website which is UK specific and not specific in a way which doesn't embrace other territories. The order does not refer to any of those top-level domain name suffixes which could be associated with the UK, like .co.uk or UK whatever, and there are quite a series of them, as you know, and it's just talking about a UK-specific website. And if something is sufficiently UK-specific to be within the embrace otherwise of 2 or 3, it's sufficiently UK-specific to be taken out of the embrace of it by B, and that's the long and the short of the argument. C, we're not concerned with, and I don't think it sheds light on anything that we are concerned with. D, we are concerned with. For the defendants to use in the ordinary course of business email addresses ending @merck.com for employees based outside the United Kingdom. the judge said this only covers employees whose names as individuals appear in the email address ending at merck.com, that it only covers fredblogs at merck.com. We say not so. You have, first of all, to appreciate this is talking about employees as such. Not individuals, it's employees, and employees have duties.
Sorry, when you say not individuals, what's the distinction you're drawing? Because to my way of thinking, an employee is an individual.
No, I'm agreeing with you. I'm saying that the judge has stopped short of having a sufficient 360-degree perspective. Can I just tease it out a little bit further? We are talking about employees as such. Of course they're individuals. They have duties, roles and responsibilities within organisations. And that is reinforced by the reference to using in the course of business the email address which is exempted by D. So you have a category of email addresses and you have a community of people who are eligible to use them. The judge has effectively said, and it's clear from the way he deals with one instance as against another, they're only immunised under this clause if they use then full, well, he didn't say full name, but personal name, fredblogs at merck.com. We say that's not right. We say that's too limited. We say...
Can you help me? What do you say is the import of the phraseology, email addresses for employees?
Yes. Suppose, and this is, I'm not sure whether I'm giving a concrete example or not, but suppose it was customer complaints at merck.com.
Why is that an email address for an employee?
Because if the people who are there to whom the customer complaints are directed are employees who are engaged in performing the duties, roles and responsibilities, they are within the class of people entitled to use an email address which ends at merck.com. It's like sending an email to my chambers address, clerks@oeclaw.co.uk. They're sitting there, they're individuals in my clerk's room. Alternatively, you can address them as individuals by name. Alternatively, you can address them as Team B at oec.org.co.uk. They are still individuals. The email address qualifies by reason of its suffix, and it has the great advantage in terms of carrying on in course of business that if the particular identity of a person assigned to the role changes because you recruit someone else, or you move the person that was previously doing the job and replace that person with another, you're not losing email contact. In other words,
Doesn't that rather illustrate the fact that it's not an email address for the employee?
Well, I would say not. I would say that, in fact, it is describing an employee by the function that that employee performs. It can be one or it can be several in a department, and describing them by a function is no different in principle, if they are all otherwise qualifying, to be regarded as the email address of an employee. Now, at this point, it would be convenient, because it permeates a lot of what I'm saying. May I, just, if you keep this open, but may I ask you to take bundle A, the authorities bundle, and turn behind tab 5. And I will, this is Michael Wilson and Emmett, which has been the subject of
endless litigation.
I believe it, yes, endless.
We're all bearing the scars.
Some I suspect more than others.
And
Yes.
there's no end, as far as I can tell, there's no end in sight, but there you go. Anyway, where was I? Right, I want this case for 2 points, if I may. Paragraph 11, which we've sidelined on page 75. we've given this as a convenient citation. Each of those cases which are mentioned in that paragraph stand for that proposition. When you are dealing with an exclusion from a court order, the burden is upon the person enforcing the order to show that the acts complained of are not within the scope of the exception. And if you were doing it in committal proceedings, you'd have to show beyond reasonable doubt. And that's solid, if I can say that. Those cases stand for that proposition. They're recorded in the textbooks for that proposition, and they've been followed quite a few times for that proposition. The exception is for the claimant to prove the defendant is not within it. Now, I mention that because the judge reversed the burden of proof on this point in relation to a paragraph we haven't got to yet, which was subparagraph H. He shouldn't have. We submitted, without being mindful of these authorities, but we submitted exactly what is here, which is that it was incumbent upon the claimant to show that the exclusion did not apply. But the judge accepted that in relation to B and in relation to D, but didn't accept it in relation to H. And H is a very important subclause. Now, the other paragraph that I want from this, please, is on page 77. We've sidelined the passage in paragraph 22 there. And you'll see, if there are two possible interpretations, a defendant who acts in accordance with one possible interpretation should not be held in contempt. Now, I have made my submissions both in relation to B and D, and I beg to submit that the submissions I have made support what you can properly call a possible interpretation of those clauses, but notably in relation to the one I was just discussing with you, which is the D clause. If that's right, if that's right, then in those circumstances, I would say that this principle comes into play when you're alleging that someone is in breach of an order. If it is right that you can refer using that email address for which the only prescribed requirement is the suffix to describe the role that an employee is performing, then I say my clients should have the benefit of that interpretation when it comes to breach, no breach on that principle. Now, with that, can I turn over the page in the other bundle behind tab 10? And go to subparagraph H. Before I look at the wording of it with you, can I just explain? So, in our skeleton of argument that we put before Mr Justice Norris on the 28th of June 2018, we proposed this provision. And we said it wouldn't be appropriate for US Merck to be at risk of being in contempt of court for inadvertently acting in contravention of onerous injunctive restrictions. We went for a hearing. The hearing took place, I recollect, from the 2nd to the 4th of July. And on the last day of the hearing, it was a 3-day hearing, yes, 4th of July, my opponents had, and the transcript accepted this wording, and they sent an email to the judge with a minute of order with this wording in it. This wording was not imposed by the court. It had the imprimatur of the court upon it. It was an agreed form of wording between the parties. The judge, in his judgment, ultimately delivered on the 20th of May, noted, I'll just give you the references, noted in paragraph 91 that he had rival forms of order in front of him. In paragraph 100, he said that there should be a cooling off mechanism under which Merck Global must notify and set time for compliance. And then in paragraph 134, brackets Roman 13, he said that there should be the inadvertent breach provision which the parties had put before him. This is, I had seen that wording in a Tomlin schedule to a case settled in the Court of Appeal involving American clients, in which they referred to this as a notice and cure provision, which is the function it performs, I believe, in American drafting practice. Now, how to interpret it? I've already indicated that the judge reversed the burden of proof on this and said that it's for me, not for the claimants, to establish that this is met. We say that's wrong. I'm not going to repeat that beyond saying it as I just have. The wording, for the defendants inadvertently to act in breach if the error is corrected within 7 days of notification in writing, or the defendants otherwise becoming aware of such inadvertent error. So what you have is an inadvertent error, I'm coming back to that, an inadvertent error, apropos which there is incognizance on my client's part until they acquire awareness of it having occurred and remedy within 7 days, or it's brought to their attention and they remedy within 7 days. It's an exclusion of inadvertent errors. It's got nothing to do with the burden of proof. As the judge saw it, the judge said that H is premised upon the existence of a breach.
Well, it is, isn't it?
I say not. And the judge, in the
How
way...
on earth do you get into it if there's no breach? Because it says to act in breach.
No. You get into it on the basis that a defendant can say, I'm within the scope of this, whether it is or it is not a breach.
It only applies if there is a breach.
No, but I'm just dealing with it from the perspective of the defendant. And that's the way the judge dealt with it when he actually came to deal with it. So can you, just to make good that point, because I can sense that it's a point that I need to address you on, if you can take, I don't want to close this up, but, well, I'm going to have to. No, I'll come back to it in a minute, sorry. Defendant says, inadvertent error. That's the last two words of that clause, inadvertent error. Then the question is, was it rectified within 7 days of the trigger point? If it was, you don't get...
If there was no breach, there was nothing to rectify.
That's the argument, and I don't accept it, and the judge didn't, in the end, apply it that way. He applied it in what I regard as the correct way, and I'll come to it in just a second. Now, the judge came to the conclusion that these words should be paraphrased, that inadvertent error should be paraphrased as genuine accident. Like every other paraphrase that you can introduce into the interpretation of anything, the paraphrase then starts to acquire questions as to what it means, and you get paraphrase upon paraphrase. So the first point is, inadvertent error means whatever inadvertent error means. The first thing I want to stress is that a volitional act can be deliberate and still constitute an inadvertent error. It all depends on what is going through the mind of the person concerned at the time that they engage in the act in question, volitional though it may be. Take an example. If there's an injunction against dealing in goods which infringe a certain trademark, and then the defendant trader subsequently deals in goods which are counterfeit goods, he's breached the order, but if there's an inadvertent breach provision here, and he was taken in by the counterfeits and he could say he didn't know, there would be entirely volitional acts, there would be a transgression of the order, but nonetheless there would be an inadvertent breach. There's a lot of law in the taxing statutes about people who wish to reopen assessments that have been made against them, and there has been for decades. The mental element is built into the word inadvertent. And what's more, because of the whole host of things that can give rise to an error being inadvertent according to the perspective of the person who is making the relevant act, it is not possible to come to an exhaustive definition of them. Either it was or it wasn't an inadvertent error. And I don't want to sound, Brexit is Brexit and all that sort of stuff. That's not the language I'm using. It's inadvertent error, and it's for, you members of the jury, you need to judge. That's why we have judges. But the one thing that it is not appropriate to do is to codify it into what the judge wanted to codify it into, which was a genuine accident. A genuine accident can be an inadvertent error, but it's not exhaustive of what can be an inadvertent error, and it's a classic example of something that will turn on its own facts. My stress is upon the mental element of inadvertent. Incorrect belief. I've borrowed from some of the case law in the tax area. Incorrect belief, misconception, misunderstanding, mistaken view, misapprehension. Now, to pick up on the point that I was just addressing you on, I need to go back to another page in this bundle in the judgment. In the core bundle, can I take you to page 132? You may wish to make a marginal note alongside paragraph 190, CF, paragraphs 124 little 2 and 135 above. Claimant made much of the point in submissions that the MSD defendants couldn't feasibly deny that a particular activity was a breach of the order and then rely on subparagraph H to contend that the relevant activity was an inadvertent error. It is convenient to deal with this submission before coming to the individual rows. I don't accept this submission as a general proposition. In the case of an alleged breach of the order, it seems to me that there is nothing in principle or logic to prevent the MSD defendants from seeking to rely upon subparagraph H as a fallback and alternative argument to the argument that independent of subparagraph H, there was no breach. The question of whether subparagraph H can be relied upon depends upon whether there was an inadvertent error, which in turn depends upon the evidence concerning the action or omission said to have given rise to the alleged breach. I see no reason why the MSD defendants cannot argue that on the evidence the relevant action or omission constituted an inadvertent error, whilst also saying for separate reasons that the relevant action or omission didn't in fact give rise to a breach of the order.
So I'm not at all clear that the judge is saying anything contrary to what I was putting to you earlier. It's a simple proposition, namely it's possible to argue in the alternative. 1, there was no breach. 2, if I'm wrong about that, it was inadvertent error.
But can I put it the other way? Which is that it's like a squeeze argument. You can go straight to the end point. You can say what I did was an inadvertent error. And if it's an inadvertent error within the scope of that clause, then you don't have to get into the question of whether 2 or 3 reaches it, because by definition it doesn't.
Seems a bit illogical to me, because the whole purpose of these carve-outs is to define something which otherwise would be a breach, not being a breach. And so the idea that you have an argument about whether it's an inadvertent error in circumstances where it might not be a breach at all just seems to me to be a bit pointless.
I beg to differ, my lady. If the defendant is able to say simply, it was an inadvertent error, and I'm not going to go into the question of 2 or 3, it would leave the claimant with the question of whether it went into 2 or 3 or not, and then into inadvertent error, but the defendant would be able to say, I have my immunity. This defines activities which paragraphs 2 and 3 don't reach. They all do. All of the subparagraphs of 4 define actions or omissions which 2 and 3 don't reach. And they do so whether or not 2 or 3 would otherwise reach them. Right, so I adhere to that submission, if I may, with no disrespect. I've already pointed out that the judge reversed the burden of proof. The main burden of my submission is that inadvertent error is not susceptible of paraphrasing, synonyms, glosses, and so on and so forth, which will simply give rise to yet further questions of interpretation. And that the net effect of this was that where the judge applied subparagraph H, even on the reversed burden of proof, he found in most cases where it was invoked that my client succeeded on the evidence before him. But there are, I've counted about 6, there may be more instances where he held that we hadn't satisfied the burden of proof, which was wrongly imposed upon us. So it's a matter of interpretation of what do you mean by inadvertent error, bearing in mind the mental element, and it's also a question of not reversing the burden of proof.
All right, is that a convenient moment?
It's a very convenient moment. I've overshot my own estimate for the first time in my life at the bar. I've got one short point to make in relation to the 4th branch of my case. Very short point, and then I'll give way to Mr. Hollingworth if that's convenient to the court.
Very good. 2.
Thank you.
All rise.